Is there any circumstance in the world in which President Trump could dodge the subpoena?
Throughout history, presidents have made unprecedented claims about the scope of their power by asserting something called executive privilege. You won't find the words executive privilege anywhere in the Constitution. It's an idea that the president can withhold certain information, even if subpoenaed by the courts or Congress.
What happens if Robert Mueller subpoenas the president? Will you comply?
Well, we don't have to. He's the president of the United States.
The Supreme Court has rejected past presidents' attempts to use executive privilege in order to shield themselves from legal process. Let's go back to Watergate. In an attempt to keep his taped conversations private, President Nixon asserted that he had executive privilege and therefore didn't have to comply with the court subpoena. Ultimately, the Supreme Court held that because the tapes were not a threat to the nation's security and wouldn't reveal military or diplomatic secrets, Nixon's resistance to the subpoena was ineffective.
The ground for asserting the privilege as to subpoenaed materials cannot prevail over the fundamental demands of due process of law in the fair administration of criminal justice.
The court required Nixon to turn over the tapes, and he resigned from office 16 days later. Or take a more recent episode involving President Clinton. The Supreme Court held in 1997 that Clinton could be civilly liable and sued while in office for actions that are unrelated to his role as president.
He holds the highest office in the land, and it's the office that's unique. It's the office that has privileges and immunities. The person only derives what he has from that office.
The court made clear in the Clinton versus Jones decision that the presidency has never extended so far as to remove the president beyond the power of the courts. The final decision read that sitting presidents have responded to court orders to provide testimony and other information with sufficient frequency that such interactions between the judicial and executive branches can scarcely be thought a novelty. In fact, presidents have been subpoenaed long before Clinton and even Nixon. Presidents Monroe and Ford were forced to comply in criminal proceedings. Meanwhile, Grant, Carter, and Reagan voluntarily agreed to provide depositions during their terms. So any president looking to dodge a subpoena should be wary, because like those that came before them, future presidents may find that their arguments don't hold up when subjected to the constitutional mechanisms that prevent abuse of power.